Hi, I'm Kellen Bryant, and I'm here to answer the question, are wills from other states valid in Florida? So there's a couple points to be made here about other states' wills moving into Florida. So if you're moving from, say, Georgia, North Carolina to Florida, this answering will apply to you. So generally speaking, the way you signed it in other states with other attorneys is usually valid in Florida. We require 2 witnesses on that will in order for the signing to be valid, in order to be a valid document. So yes, the execution is usually valid for an out-of-state wills. But there's a second part, which is point 2, which is the outside circumstances that you bring into Florida, and how Florida law treats your outside circumstances. So for one example, in the state of Florida, we have a strong homestead protection that relates to inheritance rights, as well as everyone knows, as the property tax rights. So it affects spousal and minor children inheritance rights. So that's an oddity to Florida. So that's why it's a good idea to go to an estate attorney to review your existing wills if you're coming from out of state, just to make sure there's no Florida law that kind of diverts what your plans are in the other states, because for example, that homestead law is unique to Florida, and that's something you need to review and with an attorney, and see if the will fits that situation under Florida law. Now, and then the last point I want to make is, when you bring in a will from out of state, it still doesn't hurt to have a look. A lot of people will go 10, 20 years without updating their will, and so it doesn't hurt to have a look to update your will, because maybe your financial or family circumstances change, or that will doesn't quite fit you. So if this was helpful to you, or you need your will updated, come visit my website at www.kellenbryantlaw.com to find out more information about me and my practice. Thank you very much.